Good morning, everybody. Today we are going to read Current Affairs Today of dhristi IAS, August 2022. So we will get started with polity and governance, and the first topic is one candidate, one constituency. Recently, the Election Commission sent some key proposals to the Ministry of Law and Justice regarding the linkage of Aadhaar with voter IDs, allowing 4 qualifying dates for eligible people to register as voters, banning opinion polls and exit polls, and limiting the seats from which a candidate can contest to just one. Background: as per section 33 of 7 of the RPA, Representation of the People Act 1951, one candidate can contest from a maximum of 2 constituencies. One candidate can contest from a maximum of 2 constituencies. More constituencies were allowed until 1996, when the RPA was amended to set the cap at 2 constituencies. Since 1951, many politicians have used this factor to contest from more than one seat, sometimes to divide the opponent's vote, sometimes to profess their party's power across the country, sometimes to cause a ripple effect in the region surrounding the constituencies in favor of the candidate's party, and all parties have exploited section 33(7). On the positive side, the system of one candidate, 2 constituencies provide a wider choice to the polity as well as candidates. Doing away with the provision could cause an infringement of the rights of the candidates contesting elections, as well as curtail choice of candidates to the polity. Key issues: one act negates another. Since no candidates can represent 2 constituencies, the idea of this system appears to be illogical and ironic. The irony behind section 33(7) of the RPA is that it leads to a situation where it would be negated by another section of the same act, specifically section 70. While 33(7) allows candidate to contest from 2 seats, section 70 bars candidates from representing 2 constituencies in the Lok Sabha or State Assembly. By-election strains public exchequer. The first key issue was one act negates another, and the second issue is by-election strains public exchequer. After sacrificing one of the constituencies, a by-election is automatically triggered immediately after the general election. For example, in 2014, after PM Narendra Modi won both Vadodara and Varanasi, he vacated his seat in Vadodara, forcing a by-election there. Are you getting it? Lakhs of taxpayers' rupees need to be shelled out because of a by-election that could have been easily avoided. Before 1994, when candidates could contest from even 3 seats, the financial burden was even heavier. And the major key issue is voters lose interest. Repeated elections are not only unnecessary and costly, but they will also cause voters to lose interest in the electoral process. Invariably, the by-election would most likely see fewer voters turn out to vote when compared to the first election a few days earlier. This is a very serious issue. This is a very serious issue. Key recommendation of the Election Commission. The Election Commission recommended amending section 33 part 7 so as to allow one candidate to contest from only one seat. It did so in 2004, 2010, 2016 and in 2018. A system should be devised wherein if a candidate contested from 2 constituencies and won both, then he or she should bear the financial burden of conducting the subsequent by-election in one of the constituencies. The amount would be rupees 5 lakh for Vidhan Sabha election and rupees 10 lakh for a Lok Sabha election. Exit and opinion polls. An opinion poll is a pre-election survey. An opinion poll is a pre-election survey to gather voters' views on a range of election-related issues. An exit poll, on the other hand, is conducted immediately after people have voted and assesses the support for political parties and their candidates. Both kind of polls can be controversial if the agency conducting them is perceived to be biased. The projections of these surveys can be influenced by the choice, wording, and timing of the questions and by the nature of the sample drawn. Political parties often allege that many opinion and exit polls are motivated and sponsored by their rivals and could have a distorting effect on the choices voters make in a protracted election, rather than simply reflecting public sentiments or views. Way forward. Sections of the RPA concerning the election process should be discussed and deliberated in the Parliament, and required amendments should be made to the legislation to include those raised by the Chief Election Commissioner. Here comes the next topic: recognition of sex work as a profession. Recently, the Supreme Court recognized sex work as a profession and observed that its practitioners are entitled to dignity and equal protection under law. In 2020, the National Human Rights Commission (NHRC) recognized sex workers as informal workers. Key highlights of the judgment: criminal law. Sex workers are entitled to equal protection of the law, and criminal law must apply equally in all cases on the basis of age and consent. When it is clear that the sex worker is an adult and is participating with consent, when it is clear that the sex worker is an adult and participating with consent, the police must refrain from interfering or taking any criminal action. Article 21 declares that no person shall be deprived of his life or personal liberty except according to procedure established by law. This right is available to both citizens and non-citizens. Should I read it again? Article 21 declares that no person shall be deprived of his life or personal liberty except according to procedure established by law. This right is available to both citizens and non-citizens. Sex workers should not be arrested or penalized or harassed or victimized whether there is a raid or on any brothel. Since voluntary sex work is not illegal and only running the brothel is unlawful. Rights of child of a sex worker. A child of a sex worker should not be separated from the mother merely on the ground that she is in the sex trade. Basic protection of human decency and dignity extends to sex workers and their children. Further, if a minor is found living in a brothel or with sex workers, it should not be presumed that the child was trafficked. Medical care. Sex workers who are victims of sexual assault should be provided every facility including immediate medico-legal care. Role of media. Media should take utmost care not to reveal the identities of sex workers during arrest, raid and rescue operations, whether as victims or accused, and not to publish or telecast any photos that would result in disclosure of such identities. And here are the related provisions, Supreme Court judgments in India. First is Immoral Traffic Prevention Act 1956. The legislation governing sex workers in India is the Immoral Traffic Prevention Act. The legislation penalizes acts such as keeping a brothel, soliciting in a public place, living off the earnings of sex work, and living with or habitually being in the company of sex worker. Next is Justice Verma Commission 2012 to 2013. The Justice Verma Commission had also acknowledged that there is a distinction between women who are trafficked for commercial sexual exploitation and adult consenting women who are in sex work of their own volition. And the third case related to this is Budhadev Karmaskar versus State of West Bengal case 2011. The Supreme Court opines that sex workers have a right to dignity. Here are some of the challenges faced by sex workers. First is discrimination and stigmatization. The rights of sex workers are non-existent, and those doing such work face discrimination due to their criminalized status. These individuals are looked down upon and have no place in society, and sometimes are treated harshly by their landlords and even the law. Their fight to be given the same human, health and labor rights as others continues, as they are not deemed as falling under the same category as other workers. Abuse and exploitation. Sometimes sex workers are exposed to a slew of abuses that range from physical to mental attacks. They would face harassments from clients, their own family members, the community, and even from people who are supposed to uphold the law. The way forward. It is time to recognize sex workers' work and assign morality to their work. Adult men, women, and transgender persons in sex work have the right to earn through providing sexual services, live with dignity, and remain free from violence, exploitation, stigma, and discrimination. It is time we rethink sex work from a labor perspective where we recognize their work and guarantee them basic labor rights. Parliament must also take a relook at the existing legislation and do away with the victim rescue rehabilitation narrative. Here comes the next topic. Reconstitution of the Interstate Council. Recently, the Interstate Council was reconstituted with the Prime Minister as chairman and Chief Minister of all states and 6 union territories as members. 10 union ministers will be the permanent invitees to the Interstate Council. The government has also reconstituted the Standing Committee of the Interstate Council with Union Home as chairman. The Chief Minister of Andhra Pradesh, Assam, Bihar, Gujarat, Maharashtra, Odisha, Punjab and Uttar Pradesh are members of the Standing Committee of the Interstate Council. Key points. Background. As part of the process of reviewing the working of the existing arrangements between the Union and the states, the government constituted a commission in 1988 under the chairmanship of Justice R.S. Sarkaria. One of the important recommendations of Sarkaria Commission was for establishing a permanent interstate council as an independent national forum for consultation with a mandate well defined in accordance with Article 263 of the Constitution of India. About this, the Interstate Council is a recommendatory body that has been empowered to investigate and discuss subjects of common interest between the union and state or among states. It also makes recommendation for better coordination of policy and action on these subjects and deliberation on matters of general interest to the states, which may be referred to it by its chairman. It also deliberates on other matters of general interest to the states as may be referred by the chairman to the council. The council may meet at least thrice in a year. The composition are as follows. It comprises of Prime Minister, the chairman, Chief Minister of all state members, Chief Minister of Union Territories having a legislative assembly and the administrators of UT not having a legislative assembly, and governors of state under President's rule, Governor's rule in case of Jammu and Kashmir members. 6 members of cabinet rank in the Union Council of Ministers to be nominated by the Prime Minister members. The function of Interstate Council are as follows: to create a strong institutional framework to promote and support cooperative federalism in the country and activate the council and zonal council by organizing regular meetings, facilitates consideration of all pending and emerging issues of central state and interstate relations by the zonal council and interstate council. The third function is to develop a sound system to monitor the implementation of recommendations put forward by them. Standing Committee of Interstate Council. The first point is it was set up in 1996 for continuous consultation and processing of matters for the consideration of the council. It consists of the following members: Union Home Minister as the chairman, 5 Union Cabinet Ministers, 9 Chief Ministers. The council is assisted by the Secretariat called the Interstate Council Secretariat. This secretariat was set up in 1991 and is headed by a secretary to the Government of India since 2011. It is also functioning as the secretariat of the Zonal Council. Functions. The Standing Committee has continuous consultation and process matters for consideration of the Council. Process all matters pertaining to center-state relations before they are taken up for consideration in the Interstate Council. The Standing Committee also monitors the implementation of the decisions taken on the recommendation of the Council and considers any other matter referred to it by the Chairman or the Council. The next topic is new norms for sentence remission. The Ministry of Home Affairs has issued a set of guidelines to the state and the union territories on the grant of special remission to prisoners to commemorate the 75th year of independence. Guidelines for special remission. Special remission. As part of the Azadi Ka Amrit Mahotsav celebrations, special remission would be granted to a certain category of prisoners. These prisoners would be released in 3 phases. Prisoners eligible for special remission: women and transgender convicts of ages 50 and above and male convicts of 60 and above. These convicts must have completed 50% of their total sentence period without counting the period of general remission earned. Physically challenged or disabled convicts with 70% disability and more who have completed 50% of their total sentence period. Terminally ill convicted prisoners who have completed 2/3, that is 66% of their total sentence, and poor or indigent prisoners who have completed their sentence but are still in jail due to non-payment of fine imposed on them by waiving of the fine. Persons who committed an offence at a young age 18 to 21 and with no other criminal involvement or case against them, and who have completed 50% of their sentence period would also be eligible. Prisoners excluded from the scheme: person convicted with death sentence or where death sentence have been commuted to life imprisonments, or persons convicted for an offence for which punishment of death has been specified as one of the punishments. Persons convicted with sentence of life imprisonments. Convicts involved in terrorist activities or persons convicted under Terrorist and Disruptive Prevented Act 1985, POTA Act, Prevention of Terrorist Act 2002, UAPA Act, Unlawful Activities Prevention Act, Explosives Act, National Security Act 1982, Official Secrets Act 1923 and Anti-Hijacking Act 2016. Persons convicted with dowry sentence, dowry death, counterfeiting currency notes, offence of rape and human trafficking, offences under protection of children from POSCO Act 2012, Immoral Trafficking Act 1956, Prevention of Money Laundering Act 2002, etc. Offences against the state, Chapter 6 of IPC, and any other law which the state government or the union territory administrations consider appropriate to exclude would not qualify for the special remission. What is remission? Remission is the complete ending of a sentence at a reduced point. Remission is distinct from both for law and parole in that it is a reduction in sentence as opposed to a break from prison life. In remission, the nature of the sentence remains untouched while the duration is reduced. That is, the rest of the sentence need not to be undergone. The effect of the remission is that the prisoner is given a certain date on which he shall be released, and in the eyes of the law, he would be a free man. However, in case of breach of any of the conditions of remission, it will be cancelled and the offender has to serve the entire term for which he was originally sentenced. The remission system has been defined under the Prison Act 1894 to be a set of rules formulated for the time being in force, regulating the award of marks to and the consequent shortening of sentence of the prisoners in jail. It was observed in the Kehar Singh versus Union of India 1989 case that courts cannot deny to a prisoner that benefit to be considered for remission of sentence. By denying, the prisoner would have to live in the prison till his or her last breath without there being a ray of hope to be free again. This would not just be against the principle of reformation but will also push the convict into a dark hole without there being a semblance of light at the end of the tunnel. Also, in the case of State of Haryana versus Mahendra Singh 2007, the SC observed that even though no convict has a fundamental right of remission, the state in exercise of its executive power of remission must consider each individual case, keeping in view the relevant factors. Further, the court was also of the view that the right to be considered for remission must be held to be legal one. This is by keeping in view the constitutional safeguards for a convict covered under Article 20 and 21 of the Constitution. Constitutional provisions. Both the President and the Governor have been vested with sovereign power of pardon by the Constitution. Under Article 72, the President can grant pardons, reprieves, respites, or remissions of punishment, or suspend, remit, or commute the sentence of any person. Under Article 161, a Governor can grant pardons, reprieves, respites, or remission of punishment, or suspend, remit, or commute the sentence. This can be done for anyone convicted under any law on a matter which comes under the state's executive power. The scope of the pardoning power of President Article 72 under Article 72 is wider than the pardoning power of the government under Article 161. Statutory power of remission. The Code of Criminal Procedure provides for remission of prison sentences which means the whole or part of the sentence may be cancelled. Under Section 432, the appropriate government may suspend or remit a sentence in whole or in part with or without conditions. Under Section 433, any sentence may be commuted to a lesser one by the appropriate government. This power is available to the state governments so that they may order the release of prisoners before they complete their prison terms. The key terms are pardon. What does this mean? Pardon means to remove both the sentence and the conviction and completely absolves the convict from all sentences, punishment and disqualifications. Commutation. It denotes the substitution of one form of punishment with a lighter form of punishment. For example, a death sentence may be commuted to rigorous imprisonments. Remission. It implies reducing the period of a sentence without changing its character. For example, a sentence of rigorous imprisonment for 5 years may be remitted to rigorous imprisonment for 1 year. Respite. It denotes awarding a lesser sentence in place of one originally awarded due to some special fact such as the physical disability of a convict or the pregnancy of a woman offender. Reprieve. It implies a stay of the execution of a sentence, especially that of death, for a temporary period. Its purpose is to enable the convict to have time to seek pardon or commutation from the President. The next topic is Uniform Civil Code in Uttarakhand. Recently, an expert committee was constituted by the Uttarakhand government to implement Uniform Civil Code and to check all the relevant laws that control personal matters for those living in the state. A few months ago, the Allahabad High Court also cancelled upon the central government to initiate the process for the implementation of UCC. Key points. Uniform Civil Code would provide one law for the entire nation, including all religious communities in their personal matters such as marriage, divorce, inheritance, adoption, etc. Article 44 of the Constitution lays down that the state shall endeavour to secure a UCC for the citizens throughout the Indian territory. Article 44 is one of the directive principles of state policy. DPSP is as defined in Article 37 are not justiciable, not enforceable by a law, by any court. However, the principles laid down therein are fundamental in governance. The enforcement of UCC would help narrow down the religious divide in a country like India, where people of different religions reside. The enforcement of UCC would provide protection to vulnerable sections, simplify laws, and ensure gender justice adhering to the ideal of secularism. Status of UCC in India. In most civil matters, India follows UCC such as Indian Contract Act 1872, Civil Procedure Code, Transfer of Property Act 1882, Partnership Act 1932, Evidence Act 1872, etc. In certain matters, however, there is diversity even under these civil laws, as states have made hundreds of amendments to these. Several states refused to be governed by Uniform Motor Vehicles Act 2019. At present, Goa is the only Indian state that has implemented UCC. About its origin, UCC's origin dates back to British India when a report was submitted in 1835. This report stressed on the need of uniformity in the codification of Indian law relating to crimes, evidence and contracts, specifically recommending that personal laws of Hindus and Muslims be kept outside such codification. Legislation dealing with personal issues increased. This forced the government to form the B.N. Rao Committee to codify Hindu law in 1941. What does Hindu Succession Act 1956 says? Based on B.N. Rao Committee's recommendation, the Hindu Succession Act 1956 was adopted to amend and codify the law relating to interstate or unwilled succession among Hindus, Buddhists, Jain and Sikhs. However, there were separate personal law for Muslim, Christian and Parsis. Here are Supreme Court's judgment. In order to bring uniformity, the court have often said in their judgments that the government should move toward a UCC. The judgment in the Shah Bano case 1985 is well known. Another case was the Sarla Mudgal case 1995, which dealt with issue of bigamy and conflict between the personal laws existing on the matters of marriage. The Supreme Court in Shaira Bano case 2017 has declared the practice of triple talaq-e-biddat as unconstitutional by arguing that practices such as triple talaq and polygamy adversely affect the right of the woman to live a life of dignity. The centre has raised the question whether constitutional protection given to religious practices should extend even to those that are not in compliance with fundamental rights. What are some of the challenges in adoption of the UCC? And the answer is, against this, UCC is against Indian concept of secularism. Indian concept of secularism is based on diversity of religion and people. UCC can homogenize the significant social practices. Minorities, that is Muslims, Sikhs, Christians, Buddhists, Jain and Zoroastrians, have expressed concerns that UCC can affect their religious practices and they might be compelled to follow the religious practices of majorities. Unawareness of the people. The most significant issue is the unawareness of people regarding the objectives of UCC. Lack of education, fake news, irrational religious beliefs, etc. can invoke a sense of insecurity among communities that are sensitive towards their religious and social practices. Constitutional matters. Article 25 of Indian Constitution that seeks to preserve the freedom to practice and propagate any religion gets into conflict with the concept of equality enshrined under Article 14 of the Indian Constitution. Way forward. The government and society will have to work hard to build trust, but more importantly, make common cause with social reformers and establish a dialogue with the people. Rather than an omnibus approach, the government could bring separate aspects such as marriage, adoption, succession and maintenance into a UCC in stages. Need of the hour is the codification of all personal laws so that prejudices and stereotypes in every one of them would come to light and can be tested on the anvil of fundamental rights of the Constitution. The next topic is reservation in promotion. Recently, the centre has informed the Supreme Court that quashing reservation in promotion of the scheduled caste and scheduled tribe employees in government jobs may cause employees unrest and lead to multiple litigations. Earlier, the Supreme Court refused to lay down the yardstick for determining the inadequacy of representation of granting reservation in promotion for scheduled caste, scheduled tribes candidates in government jobs. The pros and cons of reservation. First, the pros of reservation. It ensures diversity in advanced education, equality in the workplace, and offers protection from hatred. It helps in the emancipation of disadvantaged individuals and thereby promotes equality for all. It breaks stereotypes regarding caste, religion and ethnicity. It increases social mobility. It is needed to compensate for centuries of oppression and discrimination and provides level playing fields. It seeks to bring equity in society by addressing graded inequalities. Cons of reservation. There are concerns that it can lead to erosion of meritocracy. It can still reinforce stereotypes as it demeans the achievements of marginalized sections. People coming under the ambit of reservation, their success is labeled as a result of reservation instead of their capabilities and hard work. There are concerns that reservation can serve as a medium for reverse discrimination. Reverse discrimination is discrimination against members of a dominant or majority group in favor of member of a minority or historically disadvantaged group. Due to vote bank politics, even after discrimination issues have been diminishing, it is difficult to withdraw the reservation. The key judgments are as follows. Mukesh Kumar and other versus State of Uttarakhand 2020. In this case, the Supreme Court held that there is no fundamental right to reservation or promotion under Article 16(4) and Article 16 Part 4A of the Constitution. Rather they are enabling provisions for providing reservation if the circumstances warrant. However, this pronouncement in no way understate the constitutional directive under Article 46 that mandates that the state shall promote with special care the educational and economic interest of the weaker sections of the people and in particular scheduled castes and scheduled tribes. In fact, sensitivity of the welfare state towards the weaker section over decades resulted in the gradual expansion of canopy of reservation in the form of increasing classification under Article 16, a set of actions that created a wave of litigation by which resulted in the ever evolving jurisprudence of affirmative action in public employment. Indira Chowdhury judgment 1992. In the judgment, a 9-judge bench presided by Chief Justice M.H. Kania upheld the constitutionality of the 27% reservation but put a ceiling of 50% unless